Officer Day, would you open my courtroom, please?
The state of Michigan 36th District Court is now in session with the Honorable Judge David S. Robinson Jr. presiding. Court is now in session. Good morning, everyone. Good morning, Your Honor.
Good morning. All right, let's start off. Do I have the parties here on Silver Pine versus City of Detroit?
Yes, Your Honor.
One side only. How about the parties?
I believe Ms. Willett is here for the city.
Yes, Your Honor.
Ms. Willett, are you here for the city on that matter?
I am, Your Honor.
Okay. All right, who said they were here for Silver Pine? I'm sorry.
Adam Gantz, Your Honor.
Where are you, Mr. Gantz? Okay, you and Ms. Willett will stay, then everybody else is off to the waiting room. Okay, this is 823. All right, we are on the record calling file number 191828833, Silver Pine versus City of Detroit. Your appearance.
For the record, Adam Gantz, P58558 for the plaintiff Silver Pine.
Morning, Your Honor. Teresa Olet, P72765, appearing on behalf of defendant City of Detroit.
All right. On this file, discovery is closed. I was waiting for an order on attorney fees. What happened to that order?
That would have been Mr. Levenbaum. I assume that he had submitted it, but I'll certainly follow up with him on that.
Well, that was have to have been done a month ago.
Yes. I can follow up this morning. I'm surprised that it wasn't. This is the first I've heard of that.
Indeed.
Okay.
Now, where are we between you two?
We had made a demand at the last court hearing. I hadn't heard back yet. I don't know if you want me to reference the amount of the demand.
No, I do not want to hear anything about settlement negotiations. Ms. Ouellette?
I do have settlement authority. I have not gotten together with Mr. Gantz's office to discuss that yet.
Well, how do you think
Perhaps if we can
file if you don't talk?
I understand, Your Honor. I've recently obtained authority regarding this matter.
Perhaps if we can speak in a breakout room, we can hopefully resolve the matter.
Let's see if I can get a breakout room going for you. All right, Mr. Gantz and Ms. Ouellette, you off to the breakout room.
Thank you.
Thank you.
All right, do I have both parties on Kieran Richardson versus Michigan Ambulatory Services? Apparently not. What about Michigan Ambulatory Services versus City of Detroit?
Here, Your Honor.
Ready, Your Honor.
Who else is here on that?
I am, Your Honor.
All right, so Ms. Khan and Ms. Patterson. Mr.
Yeah.
Patterson, everybody else back to the waiting room. Patterson stays. Abro goes.
Your Honor, we may be able to save you some time.
Hang on for a minute, counsel.
Sure.
I can only do one thing at a time. I've got some people back from my breakout room, apparently. Let's
Yes,
hear,
Your Honor.
let's see if you're Ms. Olet, Mr. Gantz on 19182-833.
Adam Gans, P58558, again for the plaintiff. We did have a chance to talk. We exchanged numbers, but we're far apart. They probably would need a trial date.
I'm going to adjourn this matter until March 22nd. You guys get back to work, and let's, Mr. Gantz, if that partner or associate of yours or whoever it is going to file that order for attorney fees. If I don't have it by the next time we're together, then that's going to resolve the issue for me.
Understood.
That clear?
Very clear.
All right, does March 22nd work for both of you?
It does for the plaintiff.
Yes, Your Honor.
All right. March 22nd at 10 o'clock, we'll try this again.
Okay, Your Honor.
Thank you, Your Honor.
And the order for attorney fees has not been submitted. I'm going to deem it waived. I don't have time.
Understood.
Thank you. Oh, I have to read something for you because you're leaving now. Now that we have ended today's hearing, I would like to remind everyone to please complete the public satisfaction survey via the survey link I have provided in the Zoom chat. This survey is completely optional and anonymous. It will take about 3 minutes to complete. You do not need to answer any questions you do not want to, and you may end the survey at any time by clicking to the end of the survey and hitting the done button. The feedback is very important to us to help us better serve the public. We greatly appreciate your time. Thank you much. We're off the record.
Thank you, Your Honor.
Thank you, Your Honor.
Okay, give me just a second. We'll get on with your matter, Mr. Patterson. This is Michigan Ambulatory versus City of Detroit, 20156-858. Your respective appearances.
Good morning, Your Honor. Michelle Khan for the plaintiff,
Bar number.
75585.
Good morning, Your Honor. Gregory Pattison, P75963, here on behalf of defendant City of Detroit.
Now, you said you could save me some time. That means you resolved it?
Not exactly, Your Honor, but plaintiff has intervened in the underlying case in Wayne County Circuit Court. We were actually just exchanging the order. We just didn't get it in on time, but we are good to go in the circuit court action.
That's correct, Your Honor.
Okay, so you have been permitted to intervene in that action.
Correct. Yes, I've actually already filed my intervening complaint.
Okay, well then I'll be leaving you, or should I say you'll be leaving me?
One of the two.
We'll dismiss your matter without prejudice.
Okay.
Because you're intervening in the circuit court matter. And before you leave, I have to read this next statement. Now,
Again.
I gotta do this for 2 weeks. Now that we have ended today's hearing, I would like to remind everyone to please complete the public satisfaction survey via the survey link I have provided in the Zoom chat. This survey is completely optional and anonymous. It will take about 3 minutes to complete. You do not need to answer any questions you do not want to. And you may end the survey at any time by clicking to the end of the survey and hitting the done button. This feedback is very important to us to help us better serve the public. We greatly appreciate your time. Thank you both for coming in. We're now off the record.
Thank you, Judge.
Have a good day.
Your Honor, so we should still submit that stipulated order, correct?
In terms of what?
Dismissing the district court matter, or is
I'm
the
going to
court?
do that right now.
Okay,
Based on the representations of counsel. That
Okay.
matter you've been granted, just so I'm clear, you're not seeking to intervene. You have been granted permission to intervene. An intervening complaint has been filed in the circuit court.
that's correct, Your Honor.
Okay. This matter will then be dismissed without prejudice. Thank you both for coming.
Thank you,
in.
Judge.
We're now off the
Your
record.
Honor. Thank you. Mhm. Thanks, Gregory.
All right, I think this is Open MRI of Livonia versus Hanover Insurance, Citizens Insurance. Is that right?
Yes, Your Honor.
Yes.
Okay, let's call the file, then we have your appearances. This is file number 20160-566. Open MRI of Livonia versus the Hanover Insurance Company, Citizens Insurance Company, your respective appearances.
Attorney Arnold Reed on behalf of the plaintiff, P84142.
Matt Reg on behalf of the defendants, P67545.
Okay, what's the status on this file? You've been open for quite a while.
Yes, so after you had reopened this case, Your Honor, there hasn't been any type of agreement between the parties as far as a settlement. So we would ask for a discovery. We'd like oral and written discovery if possible. We want to take the defendant's adjuster's deposition to figure out why it is that they paid 100% on the first batch of scans, but are refusing to pay on the second scans.
Where are we in terms of at one time you told me that this matter exceeded my jurisdiction.
Right.
Then apparently you changed your mind. Now, are there ongoing costs or is this done? This is sort of, how to say, the charity.
So we had some scans that we thought we weren't aware of. And then once you reopened the case, we realized that there were 3 batches of scans. And defendant actually has all of these scans because EORs were issued on all of those dates. And so defense counsel should have all of that information. And in fact, at the time of our first pretrial conference with you, I believe that defendant is the one who knew about the scans, and that's why we thought we had to kick it up at first.
Excuse me just a second. I'm a little confused. I thought you represented the plaintiff.
I do, yes.
So you're telling me you did not know about the scans your client was claiming for?
So the way it works,
That's what you're telling me?
there are some scans sometimes that we don't know about. We just have bills, and we get bills, and then sometimes there are bills that are added on for different dates of service. And so in this instance, we found that there were 3 batches of scans and 1 was paid 100%, but the other 2 are the ones that are in controversy right now.
What is the total amount of the 2 in controversy scans that you are claiming?
So for dates of service that are September 30th, those are 4,295. The second dates of service, which are March 9th, are 13,885.
Now, and you're telling me there are no other claims in this matter?
The other claims for 819 were paid at 100%. And so that's why we're trying to ask for discovery and figure out why it is that defense counsel will not pay for these other batches of scans.
I doubt very seriously Mr. Riley's going to pay for anything. I think the way it usually works is the client pays, but it's been a while since I practiced law. So maybe things have changed since then. Counsel, where are we on this?
Yeah, Your Honor, there was some initial confusion because when I requested information about what's actually in dispute, they initially indicated they were not representing the March 9, 2020 scans. And that's why I was puzzled. I thought they were representing those. And if they were, and if payments had not been rendered, then we would have been above the jurisdiction. As it turns out, my client paid voluntarily the initial scans, and now plaintiff is representing, or plaintiff's counsel is representing these subsequent scans. So the parties now do not dispute what is at issue and what dates of service are at issue. It took us a while to get to that point. And I'm not opposed to some limited discovery. I can represent the reason that these MRIs are being rejected is because they are repeat MRIs for scans that were negative in the first place, and we have IMEs that were performed and cut off based on those IME results. So that's the stance. I think there's now no dispute that there's 4 MRIs here, which I think are what, $17,000 to $18,000.
Okay, 2 things. It's a good idea to know what your claim is. It's a real good idea to not come to court not knowing what it is you're claiming. So you want to, let's see, you want the deposition of whom?
Their adjuster.
All right, have the disclosures, the 302 disclosures been made?
I don't believe so, Your Honor.
Well, I'm not going to grant you any discovery. I ordered this October 19th. So what's going on here, gentlemen?
I believe that if we were to get this discovery, we'd be able to resolve this. We're just trying to figure out why it is that they paid 100%.
I want to know why you haven't complied with the court's order concerning the discovery from back in October.
Well, if I may, Your Honor, I think the problem the attorneys are running into is the matter was dismissed by the court
Based
before.
upon?
Well, it was based upon that jurisdictional issue.
Based upon the representations of counsel. I didn't just pull this out of my hat.
No,
Okay.
no,
Then we
Your
came back, so figured out we had it wrong. Court entered an order to reinstate. Why, once that happened, were the 302 disclosures not made?
Your Honor, I don't have an answer for that, but I know at this point, if we do want to move with this case, I think discovery would be the best course of action.
Well, see, that's the fun part about wearing the robe.
Could you repeat yourself, Your Honor? I can't.
I said that's the fun part about wearing the robe. I make the call.
Yes, Your Honor.
I do not issue requests. I'm not a disc jockey. I issued an order. You have not complied with it. I'm going to adjourn your matter, gentlemen, to March 22nd. If those 302 disclosures have not been made, this case will either be defaulted or dismissed. We're not going to continue with this.
Understood, Your Honor.
Understood, Your Honor.
Does that day work for both of you?
Yes, Your Honor.
I am required to read this statement. Now that we have ended today's hearing, I would like to remind everyone to please complete the public satisfaction survey via the survey link I have provided in the Zoom chat. This survey is completely optional and anonymous. It will take about 3 minutes to complete. You do not need to answer any questions you do not want to, and you may end the survey at any time by clicking to the end of the survey and hitting the done button. This feedback is very important to us to help us better serve the public. We greatly appreciate your time. March 22nd, gentlemen, 10 o'clock. Let's get the court's orders followed.
Yes, Your Honor.
Thank you, gentlemen. We're off the record.
Thank you.
Mr. Hiltner, good morning. What file are you here today on, sir?
Good morning, Your Honor. I am here on Focus Imaging as
337?
assignee of Donzel Camacho.
Okay, I think I have the.
Yeah, last three numbers, 337.
Ms. Abro, you here?
Good morning, Your Honor. I am here.
All right, let's call your file. This is case number 2016037. Focus Imaging versus City of Detroit. Your
Good morning.
appearances.
Good morning, Your Honor. Christina Abro here on behalf of Focus Imaging P78224.
Good morning, Your Honor. Philip Hiltner on behalf of defendant City of Detroit, P77913.
All right, Have you made the 302A disclosures,
We have.
Ms. Abro?
I have, Your Honor. Phil, I don't believe I've received yours. Did you send them out?
We did. I was just looking at them. Of course, I can email them to you right after this hearing again in case you didn't get them or something happened.
If they were mailed, I probably didn't get them. If you can email them to me, that would be great.
Okay, will do.
All right, so you guys need another date then, because if you haven't gone over, there's really nothing to discuss, is there?
That's correct, Your Honor.
March 22nd at 10 o'clock work for both of you?
That works for us.
One moment, please, Your Honor. March 22nd, yes, that works, Your Honor.
March 22nd. We will try this again and hopefully be in a position to do something useful.
Phil, I'm also going to email you a demand and see if we can try to get this resolved before then.
Sure.
All right, before you leave, I have something else to read to you. Now that we have ended today's hearing, I would like to remind everyone to please complete the public satisfaction survey via the survey link I have provided in the Zoom chat. This survey is completely optional and anonymous. It will take about 3 minutes to complete. You do not need to answer any questions you do not want to, and you may end the survey at any time by clicking to the end of the survey and hitting the done button. This feedback is very important to us to help us better serve the public. We greatly appreciate your time. Okay, we're done. March 22nd. Let's get the disclosures done over to the plaintiff. Let's get talking about the resolution on this file. Anything else we can accomplish today?
That's it, Your Honor.
Okay, we're all done and thank you both for coming in. Be safe.
Thank you. You as well.
Thank you, Your Honor. You too.
All right, what else we got? All right, Mr. Chewy, who are you representing?
I am here with Midland Funding on the Karen Richardson matter, as well as Jefferson Capital with Tessalia Shelley.
Okay, well, let's start off then with the 630 matter. We are on the record calling file number 20151-630. This case is entitled Midland Funding versus Karen Richardson. By a notice dated January 13, 2021, this matter is set for pretrial today, February 22nd at 10 o'clock. It's currently 10:32. I have an appearance from the plaintiff. I do not have an appearance from the defendant. Your appearance, sir?
Good morning, Your Honor. Zach Chewy appearing on behalf of plaintiff P83966.
All right, I don't have a appearance from the defendant in this matter. No good cause for that failure to appear has been shown. The court will therefore enter the default of the defendant in this matter. This is a some certain case, am I correct?
Yes, Your Honor.
All right, then I look forward, sir, you submitting your default judgment under the 7-day rule.
Absolutely.
Okay?
Thank you, Your Honor.
Yeah, because I don't have a proposed default judgment in front of me. A lot of times I do, and I can just enter that, but I don't have yours.
No problem. We will send that right away under the 7-day rule for you.
Okay, no problem. Let's do your next case, which is file number 20158-286. Jefferson Capital System versus Tesselia Shelley. Could I have your appearance on that file, sir?
Yes, Your Honor. Zach Chewy appearing on behalf of plaintiff P83966.
All right, in this one, this matter is set for hearing today, February 22nd, by a notice dated January 14th. The matter is set for hearing at 10 o'clock. It's currently 10:33. I have no appearance from the defendant. The default of the defendant is hereby entered. This time, Mr. Chewy, however, I have your proposed default judgment. You want to just use that one?
Yes, Your Honor, that would be
Okay,
perfect.
then I'll enter that default judgment today. So you only need to send in your default judgment on the other file.
Thank
Okay.
you, Your Honor.
All right, sir, thank you for coming in. Oh, whoops. I have to read my statement.
Oh,
Now that we have ended today's hearing, I would like to remind everyone to please complete the public satisfaction survey on the survey link I have provided in the Zoom chat. This survey is completely optional and anonymous. It will take about 3 minutes to complete. You do not need to answer any questions you do not want to, and you may end the survey at any time by clicking to the end of the survey and hitting the done button. This feedback is very important to us to help us better serve the public. We greatly appreciate your time. Thank you very much, sir. We're off.
thank you, Your Honor. You have a great day.
You too, sir. We're off the record. All right. Gentlemen,
Yes. Morning.
good morning. Let's get started. Oh, before we get started, I have a announcement about the public satisfaction survey that I'm supposed to read. Announcement begins. Before we begin today's hearing, I would like to talk about the public satisfaction survey. This survey allows court users to rate the court's accessibility and its treatment of the public in terms of fairness, equality, and respect. This survey will also help us better understand how we are providing service remotely. By providing us with feedback, we can make good public service even better. This survey is for everyone involved in the hearing today and will not affect your case in any way. It is completely optional and will take about 3 minutes to complete. A link has been placed in the Zoom chat, which will allow you to take the survey online. To access your Zoom chat, click on the very bottom middle of your Zoom screen that says chat. Once you open that chat, click on the link I provided and a browser window will open with the survey. In the event that the chat is closed or unavailable, the link will also be placed on this court's website, www.36districtcourt.org, under the announcement section. Okay, let us begin with our work. We are on the record. This is case number 19175.025, Saad Istvan versus Marvin Shea. We are on our continued settlement conference. Your respective appearances.
Good morning, Your Honor. Raymond Sloom on behalf of the plaintiff.
Bar number.
P36852.
Counsel.
Good morning, Your Honor. Alan Soroki, P37441, appearing on behalf of the defendant and counter plaintiff.
Okay. And also with us are Mr. Istvan and Mr. Shea, correct?
Yes, that's correct, Your Honor.
Gentlemen, have you been able to resolve this matter?
Not yet.
Sorry, Judge, not yet.
Okay. Now, last time we were together, my recollection is, Mr. Soroki, you were talking about filing some dispositive motions.
Yes, Your Honor.
I think it might be time to do that because we don't seem to be getting anywhere on settlement here.
I think that's a good move at this time, Your Honor.
Okay, this is what I'm going to do. I'm going to set this matter for hearing again, April 26th at 11 o'clock. Does that day work for everybody?
Yes.
Your Honor, can I check my calendar real quick?
Please.
That date's good for me, Your Honor.
Okay.
Yes, Judge, April 26th works for me.
Okay, then April 26th at 11 o'clock. And Mr. Soroki, how long will it take you to get your motion for summary disposition filed?
Maybe 2 weeks, Your Honor.
Okay, that'll still be enough time inside of the 3 weeks if we use that date. So what I'll do is I'll calendar for April 26th at 11 o'clock, Mr. Soroki's motion for summary disposition. Mr. Saloom, are you anticipating this positive motion on your behalf?
Yes, Judge.
Then let's get yours filed as well.
Yes, Judge.
Again, if we have enough time to get all the pleadings in, we can be heard on that day. Otherwise, if we don't have enough time, we'll just set another date. But I hope we'd be able to get all the pleadings filed in time to give the opposing party the 3 weeks necessary. So if you can get on both of those motions filed within the next 2.5 weeks, that should be plenty of time so we could actually hear the respective motions for summary disposition on that date.
Yes, Your Honor.
Yes, Your Honor.
Anything else?
Nothing further, Your Honor.
Okay, now, before you leave, I have another statement. Now that we have ended today's hearing, I would like to remind everyone to please complete the public satisfaction survey via the survey link I have provided in the Zoom chat. The survey is completely optional and anonymous. It will take about 3 minutes to complete. You do not need to answer any questions you do not want to, and you may end the survey at any time by clicking to the end of the survey and hitting the done button. This feedback is important to us to help us better serve the public. We greatly appreciate your time. Thank you, gentlemen.
Thank you, Your Honor.
Thank you.
April 26th at 11 o'clock. In the
Thank you.
meantime, let's see about getting this case settled. If not, let's get our motions for summary disposition filed.
Yes, Your
Thank you,
Honor.
gentlemen.
Yes, Your Honor. Thank you. Thank you.
Send out notice. Okay. We are now off the record.
Your Honor, my Zoom chat is disabled. It says
No.
disabled.
Those mine.
Then you can go to the court's website, www.6 36districtcourt.org.
We can log off, Your Honor.
Yep, you can log off. Thank you.
Thank you.
And that'll be under
Thank
the announcement section.
Thank you.
Thank you
Thank
all.
you. All right.
Ms. Moore,
Yes, Your Honor.
I don't have you on my docket today.
Okay,
Let me call my clerk and see if we can figure out what's going on here. Ms. Moore,
yes, sir.
you're not on my docket because the matter was dismissed on January 15th.
Okay, I did not receive an order of dismissal, so was it mailed out to us?
It was mailed out to everybody, yes.
Okay, we'll just keep watching the mail. Mail is slow.
Yeah, sorry about that.
All right, thank you, Judge.
Have a good day.
You too as well. Stay safe.
All right. Mr. Clay, you're here on Melton. Hey, good versus Mr. Clay.
Yes, sir.
And
Can you
there,
hear me?
I can hear you. And there's Mr. Melton. Hey, good. Okay, let's call your case. We seem to have everybody here. Gentlemen, before I call your case, I have a statement I need to read to both of you, and there'll be a statement that I need to read afterwards as well. You got your headphones on, Mr. Clay?
Yeah, Judge, I think I can hear you now.
Okay, let's try it again. Before
Okay.
I call your case, I have a statement to read. We're doing a public satisfaction survey announcement. So I have a statement to read before the hearing and at the end.
Okay.
Here we go. Let's start. Before we begin today's hearing, I would like to talk about the public satisfaction survey. This survey allows court users to rate the court's accessibility and its treatment of the public in terms of fairness, equality, and respect. This survey will also help us better understand how we are providing service remotely. By providing us with feedback, we can make good public service even better. This survey is for everyone involved in the hearing today, and it will not affect your case in any way. It is completely optional and will take about 3 minutes to complete. I will never see it in any event. A link has been placed in the Zoom chat, which will allow you to take the survey online. To access your Zoom chat, click on the very bottom middle of your Zoom screen where it says chat. Once you open the chat, click on the link that I provided, and a browser window will open with the survey. In the event that the chat is closed or unavailable, that link will also be placed on the court's website, www.36districtcourt.org, under the announcements section. All right, let's call your case. We are on the record calling file number 2014292, Melton Haygood versus Richard Clay. Your respective appearances, gentlemen.
Richard Clay, Your Honor.
Melton Haygood. Melton Haygood, sir.
Good morning, gentlemen. When we were last together, there was a reference to, by Mr. Clay, as I recall, that Judge Donna Robinson Millhouse, who has your landlord-tenant matter, had already issued a ruling on the question of whether this was a retaliatory proceeding. And as I recall, Mr. Clay was to obtain a transcript concerning that. Has that been done?
Yes, sir. I sent it to you in the mail, Your Honor.
When did you send it?
Probably 2 weeks ago. It's by Bernice. I think that's the court reporter name is Bernice.
Yeah,
she did it.
Yeah, I know she did it, but I'm saying, did you mail it to the court? Is that what you did?
Yes, sir. Yep, you told me to mail it. I mailed
it. It has not yet arrived. So this is what I'm going to do. I'm going to give you gentlemen another date. Does March 22nd work for both of you?
Yeah, that's cool. Cool with me.
What about you, Mr. Haygood?
I'm checking the calendar now, sir. March 22nd?
Yes.
Okay. That's fine, sir.
Okay, that works for you? Okay. Now, where are we, not on my case, but you have a ongoing landlord-tenant matter with Judge Robinson Millhouse. Where are we on that?
That's dismissed. All that is taken care of.
That's no longer live.
Yes, sir.
So the only matter we have here
is right now.
Is right here. And right now we're trying to find out whether or not there's already been a ruling by the judge as to whether or not there's a retaliatory claim here. And as I understand what you told me, Mr. Clay, you've already forwarded that transcript, but it has not arrived yet.
Yes, sir. I got everything circled and I got everything text to you to show you exactly where it said in the transcript.
I understand. Yeah. Okay, then we'll just see you then. Did you send Mr. Haygood a copy of that transcript?
Mr. Haygood got a PO box, so I didn't know if to send it to his PO box. That's the only way.
Well, he has a PO box and he receives his mail in a PO box, so I guess PO boxes work.
Excuse me.
Yes, sir.
I understand that you guys are not in love with each other. I figured that out. I don't want to hear.
Okay, I have a question.
I'm dealing with, I believe, adults, and I expect adult behavior. Sir, you had a question.
Yes, sir. What I was under the impression, and this came from Judge, I believe, Millhouse, that because my suit is a civil case, it had to go to you, and she was dealing with the landlord side.
Yes, but if there's a doctrine called res judicata, a doctrine called collateral estoppel, basically what it boils down to is you don't get to litigate the same question in two courts. If she has already made a ruling on one issue that is here between the same parties and the same issue, that ruling will be the binding ruling in this case. And that's why we were looking for the transcript.
And will I be able to see a copy of that transcript, sir?
Mr. Clay, send it to his post office box.
Yes, sir.
All right. And then we'll talk again on March 22nd at 11 o'clock. I'll send out notice today.
22nd at 11 p.m. a.m.
All right. Now, I got one more statement for you, gentlemen. Now that we have ended today's hearing, I would like to remind everyone to please complete the public satisfaction survey via the survey link I have provided in the Zoom chat. This survey is completely optional and anonymous. It will take about 3 minutes to complete. You do not need to answer any questions you do not want to, and you may end the survey at any time by clicking to the end of the survey and hitting the done button. The feedback is very important to us to help us better serve the public. We greatly appreciate your time. Thank you,
Hey, Judge, I got one more question, Judge.
Sir?
I have one question. So just how I had to pay the court recorder to go get that transcript, can Mr. Hager also pay that court recorder to get the transcript? If that's what he needs to do, I have to do the same thing.
Well, here's the situation. If you are going to file a motion based on the transcript, you will have to append the transcript to it anyway.
Okay. All right.
That will be at your expense in any event. So the purpose of having you send the transcript now is to see if we can't short circuit the process. Okay. But he's going to get the transcript at your expense either way. Either when you file your motion, because it'll have to be supported by the transcript, or not.
Oh, okay. Okay. I think I had one more question. Sorry, Judge, but I had one more question. I think I had a civil suit that I won against Mr. Hager for 10 months of rent. That also comes to you?
No.
That I had to do online?
No. Here's what I think probably happened. In the lawsuit that you had with the judge, typically what happens, did you serve Mr. Hager personally?
No, right now they said I had to do everything online.
If you didn't serve him personally, then what you got was a judgment that's called a possession judgment. And the possession judgment says, this is the amount of money you must pay in order to retain possession. It is not a money judgment. You can only get a money judgment by serving Mr. Haygood personally. And you say you didn't serve him personally. So what you got sounds like a possession. That is, he could either vacate the property or pay the money. Is that what the judgment provided?
No, this is something different, Your Honor. The judge already got Mr. Hager out, but Mr. Hager still had a balance with me that I wanted to put.
Yeah, but that's what I'm trying to tell you.
Okay.
The best thing I would say to you, you would be wise. You would both be wise to get counsel. I don't know how many times I have told you this. I am not permitted to give legal advice to either side.
Okay.
And a lawyer can explain to you which type of judgment you have. Do you have a money judgment, or do you have a judgment to retain possession? I cannot tell. I don't know. It's not in front of me.
Okay.
March 22nd, 11 o'clock. In the meantime, you will send a copy of the transcript to Mr. Haygood at his post office box. Thank you, gentlemen.
Thank you.
March 22nd. Thank you all for coming in.
Thank you very much, Judge.